received her in political science with honors from the University of Montana in 1970. She received her JD with honors from the UM Law School in 1977 and then worked in the Missoula City County Attorney's Office for 6 years. She then became a bond counsel with the law firm Dorsey and Whitney. As a bond counsel, Ellingson worked on local public projects, schools, sewer systems, libraries, swimming pools, and at the state level, helped to form Montana's tax increment financing law and the intercap program that allowed local governments to borrow money from the state at a lower interest rate. Mae Nan received national acclaim for her work as a bond counsel, elected as an initial fellow to the 1995 American College of Bond Counsels, and was recognized as a super lawyer in the Rocky Mountain West and named one of America's leading business lawyers by Chambers USA, ranked #1. She was elected a delegate to the Constitutional Convention from Missoula in 1971, the youngest of the delegates, and was recognized as one of the convention's 10 outstanding Constitutional Convention delegates. At the convention, Mae Nan led proposals for the State Bill of Rights, particularly related to equal rights for women. She and Delegate Bob Campbell, who was also from Missoula, are credited with the language in the Preamble. Mae Nan is a lifetime advocate for equal rights for women, especially before the Montana legislature. Please give a warm welcome to Mae Nan Ellingson. I am so excited and honored to be here with the League of Women Voters. Without the League of Women Voters, Montana would not have this Constitution. They were absolutely invaluable in leading the efforts to get the legislature to call for a vote on the Constitutional Convention. Lucille Spear, early member of League of Women Voters, she wrote "We the People," an article or pamphlet really about why we needed a new constitution. The League of Women Voters took that and ran with it, secured an overwhelming vote to call a constitutional convention, which began in January of 1972. And then after we signed the Constitution in March 24th of 1972, the League of Women Voters took to every forum you can imagine across the state to lobby for the ratification of the Montana Constitution. So, League of Women Voters, thank you for this Constitution. I do have some prepared remarks, and I will get to them, but a couple of things that have come up in listening to Rhonda and some of the questions that I feel I want to say before I get into my remarks. One thing I would really like to do is my fellow delegate and good friend and co-author of the Preamble, Bob Campbell, is in his last days. And in his honor, I would like to read aloud the Preamble. We, the people of Montana, grateful to God for the quiet beauty of our state, the grandeur of our mountains, the vastness of our rolling plains, and desiring to improve the quality of life, equality of opportunity, and to reserve the blessings of liberty for this and future generations, do ordain and establish this Constitution. So I'd like to ask you to tip your glass to Bob Campbell, who was one of the first males admitted to the League of Women. There are just so many, interconnecting things. I also
want to read the provision in the education article. It's something that Rhonda spoke to and John Fletcher spoke to. You probably know that there was not a single Native American elected to the Constitutional Convention. One major reason for that is that at that time, elections were held at large. So Missoula elected 8 candidates at large and 100 were elected across the state. Bob Campbell says that one of the most memorable experiences for him at the Constitutional Convention was when Jeanette Rankin came to speak to us. And one of the things Jeanette Rankin encouraged us to do was adopt single member districts, because she believed it was better for women being elected. She believed it was better for minorities being elected. You know, and there was one example of Chet Blaylock. He lived in Yellowstone County, and Democrats never got elected, although there was a really strong labor movement because there was a Conoco refinery. And with the advent of single member districts beginning in 1973, we've seen an increasing number of Native American legislators and more women, although I'll talk a little bit about the number of women at the Constitutional Convention. I do want to mention, even though no Native Americans at the convention, Earl Barlow, who was then the head of whatever Indian education we had in the state, he made a proposal that we include something in the Constitution about Native Americans. And he was indefatigable in his efforts to make that happen. And young women from the Crow tribe and the Sioux tribe came and gave testimony about why they wanted recognition in the Constitution. So our education article does contain this provision. The state recognizes the distinct and unique cultural heritage of the American Indian and is committed in its educational goals to the preservation of their cultural integrity. Now, it took about 30 years before Carol Juneau sponsored the Indian Education Act for All, and Brian Schweitzer put it in his budget. So it was a long time coming, but John, I will say I believe it is robust, that if you visit the Indian Education for All website in the Office of Public Instruction webpage, you will be very impressed. And one of the things that's most impressive is that they've done an amazing lesson plan on the Montana Constitution. So those were details I wanted to, well, I'm not quite done. I have to say that this book, coming out when it did, and Nancy recommending it to me and telling me that Elaine was going to be here, has been one of the most inspiring and, well, inspiring but also challenging, heartbreaking, and also reassuring. Recalling these huge, long roads to suffrage, to equal rights, and the women who've gone before us in carrying on these battles is just amazingly inspiring. And I am so grateful to you, Elaine, for writing this book and really telling the stories of these women. Thank you.
Thank you.
Now to the Equal Rights Amendment. You know we still don't have it, right? Okay. Just one, make sure. I decided to kind of label this talk equality under the law and equality in the law. And as you know, the supreme law of both our state and the federal government is the Constitution. The Equal Rights Amendment was introduced in every Congress from 1923 to 1972. The first version was written by Alice Paul and Crystal Eastman, was introduced in December of 1923 with the sole purpose of amending the Constitution to guarantee equal rights for all Americans, regardless of sex. The language varied only a little bit from year to year. Like the 19th Amendment, the Equal Rights Amendment provoked fear, antagonisms, and had supporters and foes that seemed confounding, absolutely confounding today. It was generally supported by middle-class women, and from 1940 to 1980, the Republican Party platform called for the adoption of the amendment. The ERA was generally opposed by labor unions, New Dealers, and Eleanor Roosevelt. Yes, and Carrie Campbell. Not only was there a concern that women needed more protections, but there was a concern in the Democratic Party that it would undercut the male-dominated labor unions that were a core component of the New Deal. Northern Democrats who aligned themselves with the labor movement opposed the ERA. President Eisenhower was the first president who openly asked Congress in 1958 to approve the Equal Rights Amendment. It was introduced, but it was then amended with the Hayden Amendment by Senator Carl Hayden, who added that this equal right shall not take away from all the special privileges and protections that we grant to women. That was not acceptable to the major proponents of the Equal Rights Amendment, and so it was defeated. In 1960, President-elect, or candidate then, John Kennedy, announced his support for the Equal Rights Amendment in a letter he wrote to the National Women's Party. Once elected, he named Esther Pearson as his Assistant Secretary of Labor. She strongly opposed the ERA because she felt it would weaken women's protective legislation. Instead, she favored, quote, specific bills for specific ills as an approach to equity for women. Due to ties with labor, President Kennedy no longer supported the Equal Rights Amendment. As evidence of these specific bills for specific ills, the Civil Rights Act of 1964 was passed, which guaranteed or prohibited discrimination in the workplace on the basis of sex, race, religion. This Civil Rights Act, again, Alice Paul, still fighting her fight, was one of the advocates for this, as with Coretta Scott King and Representative Martha Griffiths from Michigan. So there were still efforts to get the Equal Rights Amendment, but some attention turned to the gain made in the Civil Rights Act. But there came to be a growing frustration with the lack of enforcement under the Civil Rights Act. And Alice, in 1967, as a result, now was formed, the National Organization of Women was formed in 1966. And in 1967, at the urging of Alice Paul, now became a strong advocate for the Equal Rights Amendment. And probably the biggest turning point that helped in the movement toward the Equal Rights Amendment, it was really kind of what historians have referred to as the second wave of feminism, was the Women's Strike for Equality in 1970 in New York City, led by Betty Friedan and others. Even though there were only 20,000 people at that march, which seems quite small based on other marches, it captured the attention of a lot of people, and it seemed that now was the time. Martha Griffith, again, in 1971, introduced the Equal Rights Amendment, which said very, very simple words: equality of rights under the law shall not be denied or abridged by the United States or any state on account of sex. It was very specific to gender discrimination because, of course, we have had the other amendment, 14th Amendment, the 15th Amendment, that protected race as a guaranteed class. This time, it approved the House, was approved in the House October 1971 by a vote of 354 to 24. Really quite overwhelming, considering that the League of Women Voters still did not support the Equal Rights Amendment. They did come around in 1972 after it was introduced in 1971. The 1971 session of Congress adjourned without the amendment being approved by the Senate. It was approved the next year in the Senate on March 22nd, 1972. Now, by then, the delegates to the Montana Constitution, we had already adopted our own version of the Equal Rights Amendment. At the time we were elected in the fall of 1971, we knew it had been introduced in the House. We knew that it had been passed in the House, but we had no way of knowing whether it would pass in the Senate. And even if it were passed in the Senate, that was not a consideration as to whether or not we should have our own Equal Rights Amendment in the Montana Constitution. Because just like the 1889 Constitution, and unlike the federal Constitution, for which the Bill of Rights was an afterthought, we knew we would have a very, very strong Bill of Rights. And as it turns out, we do have one of the strongest of any state constitution. After we started to convene in January of 1972, delegates were able to submit delegate proposals for articles and provisions that they wanted in the Constitution. There were 19 women out of the 100 elected, which was the highest number of women ever elected on a statewide basis or for an office like that in the state of Montana. The highest number of women that ever served at one time in the legislature prior to that was two. So there's a good explanation for why that happened, and the explanation is that the Montana Supreme Court ruled that sitting legislators, all but one of whom were men, could not run for election because the old Constitution said you cannot hold two offices under the Constitution at one time. So with that 150 politicians, if you will, out of the way, it really opened the door for women who really cared about government, who really had been, I won't say relegated, but they were serving as city council members, as mayors, as officers of the League of Women Voters in AAUW, and they took the bull by the horns and said, we can do this. We can do this. And indeed, they did, 19 of them. So there were a lot of delegate proposals for an equal rights amendment to the Montana Constitution. Some favored kind of a simple approach, very much like the federal Constitution. Virginia Glenn, she just wrote, there shall be no discrimination on the basis of sex. What ultimately happened was a much more expansive statement of rights. It wasn't just one dealing with sex. We have in Section 4 of Article 2 what is known as the Equal Dignities provision, which reads, the dignity of the human being is inviolable. No person shall be denied the equal protection of the laws. Neither the state nor any person, firm, corporation, or institution shall discriminate against any person in the exercise of his civil or political rights on account of race, color, sex, culture, social origin or condition, or political or religious ideas. This provision is broader and more expansive than any comparable provision in any state constitution, and far more so than any of the protections in the Federal Bill of Rights, most notably because even the Equal Rights Amendment as proposed only forbid the state and the federal government from discriminating on the basis of sex. Our Constitution prohibits private action, meaning corporations cannot discriminate. All kinds of social contracts, homeowner, the gamut, it covers everything in terms of state and personal action. Now, as most of you probably know, this, what I consider to be a great constitution, was very narrowly approved by the voters, very narrowly approved. 2,532 votes. Yes. And then there was a question about whether it had actually been approved by a majority of the people voting at the election. And this was kind of a tricky, nuanced thing. The delegates, if you poll the delegates, we would have abolished the death penalty. But we were afraid if we abolished the death penalty, the Constitution would be defeated. There was, the old Constitution prohibited gambling. there was a very large group of people, tavern owners, and we know they can be influential even from the 19th Amendment. don't we? They really wanted gambling, but the religious, and they weren't even right. I mean, even the religious mainstream didn't want gambling. So we made the decision to put those two things on the ballot as side issues. Do you want gambling or not? Do you want to abolish the death penalty or not? And the third side issue we gave them had to do with whether to have a unicameral or bicameral legislature. So what happened in Silver County, there was so much enthusiasm for gambling that they all voted yes for gambling, but they didn't vote yes or no on the Constitution itself. So then the courts just said, well, if you looked at everybody who voted at the election, it didn't pass by a majority, right? Because we had all those people voting, but they didn't vote for the Constitution. So the courts had to construe the language of the old Constitution to determine whether it had been approved. And they concluded, again, this was a squeaker, a 3-2 vote in the Supreme Court, that it had been approved by a majority of those voting on the question of the ratification of the Constitution. So this wasn't a lot easier than getting the right to vote, you know. It really wasn't. So one of the big things that the Constitution did was provide for annual sessions of the legislature. Previous to that, we had biennial sessions, and so that had a very ominous history, I guess I would say. In the 73 legislature, the ERA, ratification of the Equal Rights Amendment, was proposed to the Montana legislature. Given the fact that there had been almost no opposition in the Constitutional Convention to having this broad sweeping anti-discrimination provision, we thought ratification of the ERA would be a slam dunk. Well, it actually was that first year in 1973. It passed the House by a vote of 72 to 23. It didn't get out of the Senate. In 1974, it didn't have to be reintroduced in the House. 1974, it was approved by the Senate, but by a 29 to 21 majority. Now, I think that probably should have telegraphed to us something's going on here. And we figured it out. We did figure it out. In the 3 years since the ratification of, or the introduction and the approval of the Equal Rights Amendment, the anti-ERA movement had developed a fervor that was really not unlike the fervor of the anti-suffragists. They effectively stymied the ratification in the 4 needed states. We were the 34th when we ratified in 74. We still needed 4 more. From that day on, they effectively stymied the ratification until after the period for ratification. Now, in Montana, there was an effort to rescind our ratification every single session. 75, 77, 79, and it was the fight of our lives. I had never seen or heard of the Eagles Forum in Montana until 1975. And they showed up in full force in 1975 to lobby for the rescission of Montana's ratification. Not only were we overwhelmed by the numbers of people they brought at the legislature, the influence they brought to bear on the legislature, we saved the ratification, or defeated the rescission, I should say, on a tie vote that year. But things got worse. 1975 was the International Year for the Women, determined by the United Nations. And President Carter asked every state to hold a forum within their state for the purpose of addressing issues of importance to women, and to then consider measures and make recommendations on behalf of all the states to a big forum that would be held in Houston the following year. Montana, in the summer of 1975, I was a law student then. Some of my friends and I showed up. Sorry, Diane Sands isn't here because she was there to witness this horrible event. We showed up at the Civic Center in Helena, this big, beautiful building, this big Masonic dome, to find a bunch of men with walkie-talkies, more women than you could imagine, wearing beehive name tags. This event had been hijacked, and I use that word with all of its meaning. The way this meeting was supposed to work, there were 2 days of breakout sessions on things like women in the military, childcare, pension systems. You know, we talk about a cafeteria plan of pensions to help women get what they needed in pension systems, women in education, Title VII, a whole panoply of things. And there were resolutions that were being considered. The women, such as myself, League of Women Voters, AAUW, others who attended, we could not get a single proposal or proposition through. Not one. Some of the leaders, Diane Sands, I think, led the group to boycott and move the meeting across the street to a park, and kind of held their own rump International Women's Forum, and did come up with some resolutions. But then there was just a big brouhaha about who would be seated or recognized at the meeting in Houston. So I had what I thought at the time was a great pleasure and honor of debating the Equal Rights Amendment in a plenary session with a woman from the Eagles Forum. You know, and I was a second-year law student, just had written the state constitution, and I thought, I can handle this. You just have no idea what it's like to be debating something in front of a totally hostile audience and getting booed and booed and booed. Yeah, it was a really interesting experience. One of the things that became clear to me as I think about it now and as I read this book, kind of the worst kind of battles I think to fight are women fighting women. You know, really, women fighting women. And women feeling threatened by what they perceive to be the motives of the women on the other side. The same things came up in this meeting and in the ratification efforts for the Equal Rights Amendment, same-sex toilets, drafting women, women losing all kinds of rights, women not being able to stay at home and be homemakers, the value of homemakers not being valued. It's the same story 100 years later. Now, where are we? We have this really strong amendment or provision of the Bill of Rights in our Constitution. There is, as some of you probably know, some talk about wanting to repeal this socialist rag, as a legislator from Kalispell has referred to. There will be a vote on whether to call a new constitutional convention in 2030, because the Constitution does require that every 20 years, the voters of Montana be given an opportunity to decide whether their Constitution still fits their needs, it still has their values. And so that election will be coming up in 2030. And I think it's incumbent on the league and others of us to start educating now about what is in this Constitution. There is talk that if the Republicans get a supermajority in this next legislative session, they may go ahead and call for an amendment or another constitutional convention before then. I don't know how deep that sentiment runs within the Republican Party. I hope not very deep, because truthfully, this Constitution, it's not a partisan document. As you probably all know, we sat alphabetically. We never caucus on any items with respect to the Constitution. So it was not a partisan document. I think it's clear to say that the shift, because of Reynolds versus Sims and Baker versus Carr, had shifted from rural. So there was more urban people at the convention than there had been before. The statistics show that people from the cities voted for change more frequently than did the people from rural areas. So that's not to say, that there wasn't kind of some split among how progressive this document should be or could be, but it was not a partisan one. It was really more urban, rural split. So on the state level, thank goodness we have our Constitution, and thank goodness we still have an independent judiciary that is independent and can interpret what that means. There is, I believe, an effort afoot. If they can't immediately change the Constitution, they will change the court, as we have seen on the federal level, because ultimately it's the court that decides what these constitutions, state or federal, mean. And right now we are seeing battles. We have a very strong right of privacy in our Constitution, and there is litigation to say or determine what that means in the context of choice. And it's interesting, in looking back at my notes, some people felt that even the Equal Rights Amendment, the non-discrimination on the basis of sex, would legalize abortion. I hadn't realized that had been part of the package as well. So, as you know, the other states, 3 now, the needed states to get the ratification up to 38 has happened. There is still efforts for some states that ratified to rescind, and there's federal legislation now pending as to whether or not Congress can extend the ratification date in order to have the Equal Rights Amendment be declared to be part of the United States Constitution. That's in the courts. My own view is we probably ought to just start over. Because I think it will be tied up in courts forever. You know what, I mean, whether a state can rescind or not, you know, that's a whole, that's bringing about all kinds of inconsistent results. So do I think we need the Equal Rights Amendment? A lot of people say no, because the courts had interpreted the 14th Amendment, the Equal Protection Clause, to give women the protections that they would gain under an Equal Rights Amendment. But having witnessed the change in the makeup of courts, I'm not willing to put my faith in that. Justice Scalia, when he was still alive, spoke to this point on being asked whether or not the Equal Rights Amendment was needed. He says, certainly the Constitution does not require discrimination on the basis of sex. He says the only issue is whether it prohibits it. It doesn't. It doesn't. So I believe to have true equality in the law and not relying on the 14th Amendment, we need to have in the fundamental document of this country a clear prohibition about discrimination on the basis of sex. And, you know, if Susan B. Anthony, Carrie Catt, Alice Paul can fight for 100 and some odd years to get the vote, we can continue to fight for this.